A tenant may use either an assignment or a sublease to convey his interest in leased premises to someone else. Which of those he chooses can mean serious differences in rights and money. The court in Jaber v. Miller had to ask whether the characterization of a transfer as an assignment or a sublease should be based on law dating from 1371. Jaber rented a building for a 5-year term, from March 1, 1946 to March 1, 1951. The lease set the monthly rent at $200 and provided that it would terminate if the building burnt down. Jaber ran a shop in the building until 1949, when he transferred the lease to Norber Son. The document transferring the lease was entitled, quote, "Contract and Assignment," unquote. It stated that Jaber transferred and assigned the lease contract for the remainder of term. In exchange, Norber paid $700 up front and executed 5 promissory notes of $700 each to be paid to Jaber every 4 months. Norber would pay the building's owner the $200 monthly rent. Jaber reserved the right to retake possession if Norber didn't pay either rent or notes. The document didn't mention the possibility of fire. Norber then transferred the lease to Miller. Miller arranged with Jaber to divide the promissory note payments into monthly installments of $175. The agreement would end on March 1, 1951. Jaber accepted this new agreement in substitution for his agreement with Norber. In December 1949, fire destroyed the building. Miller sued to cancel the 14 promissory notes Jaber still held. He argued that Jaber's transfer of the lease to Norber had been a sublease, not an assignment, and that the promissory notes were rent. Because a sublease terminates when the primary lease terminates, his sublease terminated after the fire, so he no longer had to pay rent. Jaber countered that the agreement was an assignment, not a sublease, and that Miller still owed the payments. The trial court concluded that the contract was a sublease and the notes were rent and canceled the agreement. Jaber appealed to the Arkansas Supreme Court.